Good afternoon and welcome to the Supreme Court of the United Kingdom. Today we are hearing an appeal in the case of Kabab-Ji SAL, a Lebanese company, and Kout Food Group, a group based in Kuwait. The appeal principally raises questions about the identification of the parties' choice of law in an arbitration contract and the application of the summary judgment test to a claim under the New York Convention. The appellants Kabab-Ji are represented today by Mr. Nicholas Shea and the respondents by Ricky Diwan QC. The panel sitting today comprises me, Lord Hodge, and sitting with me is Lord Lloyd-Jones, Lord Sales.
Good morning.
Lord Hamlin.
Good afternoon.
And Lord Leggett.
Hello.
I now invite Mr. Shea to begin his submissions.
My Lord, I'm grateful. The relevant contracts in issue before this court are the Franchise Development Agreement, which I shall call the FDA, and the Franchise Outlet Agreements, which I shall call the FOAs. Now, my Lords, the clauses principally relevant to this appeal in each of the FDA and FOAs contain precisely the same language, so I'll generally refer to the relevant FDA clause number and language alone. My Lords, as you'll be conscious, in its recent decision in Enker concerning an English seat arbitration under Part 1 of the 1996 Act, this court restated and clarified the common law test to determine the law applicable to arbitration agreements. Now, while Enker was not a Part 3 New York Convention case, in their reasoning and reflections as to how the English common law test to determine the law applicable to an arbitration agreement should be stated, the panel took into account the specific conflict of laws rules set out in Article 5(1)(a) of the New York Convention, and I shall therefore make extensive reference to the Enker decision in the appellant's submissions on the law in this appeal. In my opening submissions, I will address sequentially the three issues which the court has summarised and defined in its handout to the parties, and in doing so, I will cover each of the 5 grounds set out in the appellant's notice of appeal. The first issue is what I call the choice issue. So that is issue 1, whether the Court of Appeal erred in finding that the parties made an express choice of English law and not an implied choice of French law as governing their arbitration agreement. Now, the grounds of appeal which are relevant to issue 1 are grounds 1 and 2, namely in Précis for ground 1, there was no express choice of law applicable to the arbitration agreement, nor still any implied choice made by the parties to the FDA. The appellant's primary submission under issue 1 and ground 1 will be that the FDA and the FOAs which amalgamate English law and unidroit as applicable to those contracts are equivocal in respect of choice of law, and there was no express choice of law applicable to the arbitration agreement made by the parties, nor still any implied choice of law. And consequently, our primary submission is that the default rule under Article 5(1)(a), discussed in this court's decision in Enker at paragraphs 289 to 291 per Lord Sales, applies. And the arbitration agreement is governed by the law of the country where the award was made, namely France. Ground 2 in Précis, which is relevant to issue 1, is that if there is an implied choice, it is an implied choice of French law. And if none, then the law of the country where the award was made applies, as I've already said. Our primary submission in respect of ground 2 will be that should this court determine that there was no express choice, but also find that there was an implied choice of a law applicable to the arbitration agreement as opposed to no implied choice, then we will submit that any implied choice of law applicable to the arbitration agreement was an implied choice of French law. Why? Because French law is the law of the neutral third country seat specifically and expressly chosen by the parties who had stipulated an amalgamation of laws to apply to the substance of their contract, and that they should, to use, in fact, the precise language of FDA Article 14.3, second sentence, and we'll be going there later, it's a bundle page 378, they should also apply unidroit, in addition to English law. My Lords, I'm coming on now to some general introductory submissions concerning the commercial reality of the relevant contract and the arbitration agreement which is in issue here. In the SAL America case at paragraph 51, and that's bundle pages 1652H to 1653B, Lord Justice Neuberger, as then he was, said the following: given the desirability of certainty in the field of commercial contracts and the number of authorities on the point, it is at least at first sight surprising that it's by no means easy to decide in many such cases whether the proper law of the arbitration agreement is 1, that of the country whose law is to apply to the contract, or 2, that of the country which is specified as the seat of arbitration. However, once it is accepted that that issue is a matter of contractual interpretation, it may be that it is inevitable that the answer must depend on all the terms of the particular contract when read in the light of the surrounding circumstances and commercial common sense. My lords, in this court's decision in Enker, at paragraph 29, and that's at bundle pages 1730D to E, my lords, Lords Hamblin and Leggett confirmed that English common law rules should apply as the law of the forum to the question of determining whether the parties have chosen the law applicable to the arbitration agreement. And that, of course, is in relation to the English common law test. And they cited Lord Diplock. I'll read out paragraph 29. I think it bears reading out. The starting point of common law, as under the Rome regulation, is that contracting parties are free to choose the system of law which is to govern their contract, provided only that their choice is not contrary to public policy. The court must therefore construe the contract to see whether the parties have agreed on a choice of law to govern it. As Lord Diplock explained in the Compagnie Tunisienne case, the first stage, therefore, any question arises between parties to a contract as to the proper law applicable to it, is to determine whether the parties intended by their contract to exercise any choice at all, and if they did, to determine what was the system of law which they selected. In determining this, the English court applies the ordinary rules of English law relating to the construction of contracts. My lords, Wooden Capita is the latest leading authority in this court on English contractual interpretation. And in that case, my Lord Hodge said at paragraph 10, and that's bundle 1676B, that, I quote, the court must consider the contract as a whole, and depending on the nature, formality, and quality of drafting of the contract, give more or less weight to elements of wider context in reaching its view as to that objective meaning. Also, in 2010, my lords, in the case of Re Sigma, this court, per Lord Collins, stated as follows: in complex documents of the kind in issue here, there are bound to be ambiguities, infelicities, and inconsistencies, and over-literal interpretation of one provision without regard to the whole may distort or frustrate the commercial purpose. My lords, the excerpt of that judgment is in the authorities bundle. It's at Lewison, paragraph 7.13, which is bundle page 2669. As my Lord Hodge went on to observe at paragraph 11 in Wooden Capita, and that's bundle page 1676, the court must not lose sight of the possibility that a provision may be a negotiated compromise, or that the negotiators were not able to agree more precise terms. And at paragraph 13, also in Wooden Capita, my lords, Lord Hodge continued, and this is bundle page 1677, negotiators of complex formal contracts may often not achieve a logical and coherent text because, for example, of the conflicting aims of the parties, failures of communication, differing drafting practices, or deadlines which require the parties to compromise in order to reach agreement. My lords, as I hope to show you in the appellant submission, the key to solving the issue 1 question in this case lies in the difference between that which is equivocal, be it the language of the relevant contracts, or words, or conduct, and that which is unequivocal, as I will hopefully now demonstrate. What the facts of this case show is as follows. In their choices of law when contracting, international parties do not always make logical or simple choices concerning the law applicable to various parts of a contract, because the very act of reaching agreement on the terms of a contract may involve degrees of compromise by one party or another. The appellant ventures the observation that the commercial and cultural reality of international contracts is that the language and choices, for example, choices as to which laws apply, which may be made by non-English and international parties whose mother tongue is not English, may often not achieve the type of logical and coherent text which a judicial eye may expect or perhaps hope to see. Indeed, the amalgamation of laws chosen here by the parties to the FTA and the FOAs calls to mind, we say, another such example, namely the amalgamation of laws selected by the parties in the Channel Group case, which came before the House of Lords some 30 years ago when the Channel Tunnel linking France and England was under construction. Now, the governing law provision which the parties agreed in that contract may well have had to do with French and English parties having to reach compromise in order to finally reach agreement to build a submarine tunnel between their countries at all. And in order to achieve that objective, they made a choice to amalgamate laws in a manner which was surprising, for they stipulated at clause 68 of their contract the following amalgamation of applicable laws. And this is, my lords, at bundle pages 1468E to F. Clause 68 of the contract is to the following effect. The construction, validity, and performance of the contract shall in all respects be governed by and interpreted in accordance with principles common to both English law and French law. And in the absence of such common principles, by such general principles of international trade law as have been applied by national and international tribunals. I note, my lords, that in respect of this applicable law clause, that it was written in language which had a subtractive effect. Now, by that I mean that it states that only the common principles of English and French law were to be applied. And in the absence of such common principles, then the applicable law or legal principles would effectively be such general principles of international trade law as have been applied by national and international tribunals. My lords, we say that the commercial reality of international contracts is that they are not always a product of ideal, logical, or sensible thinking even by parties if one is to think from a legal perspective, because the rigors of negotiation and achieving agreement at all may constrain the language in which the relevant contract ends up being expressed. And so it is, we say, that international contracts are not necessarily models of the clarity of thought or logic, and certainly which don't take into account any policy objectives, which judicial thinking can bring to bear when examining a contract ex post facto. The drafting of international contracts and the terms eventually agreed, even between sophisticated parties from different countries and cultures and systems of law, often betray the obvious tension in negotiations, which has led to a compromise in language and conditions which end up being the conditions and the language which constitute the contract which those parties agree, and therefore which do, whether muddled, whether not muddled, whether clear.
I think Lord Leggett has a question for you.
Oh.
Very interesting disquisition, Mr. Say, but we don't have to deal with a clause like clause 68, fortunately, of the Channel Tunnel Agreement. We have to deal with a clause that says this agreement shall be governed and construed in accordance with the laws of England. And it's hard to see much muddle or confusion in that. Couldn't be much clearer, really, could it?
Well, my lord, we say that it could have been much clearer because of the other language in the contract. I will be coming on to make some submissions about the specific language of Article 14 and also Article 15, and the use of the words govern as opposed to the use of the words apply when I examine the language of the contract. Does that assist, my lord?
Well, it may do when we get to the contract, but I'll wait with bated breath.
My lords, we say that the reality is that compromise is often found within the drafting and the language of the contract, and that may create equivocation with the language of the resulting contract, as with the FDA in this case. Now, with the FDA, we say that the compromise found by parties in order to reach agreement in that contract contains certain express provisions which constitute choices to multiply and amalgamate the laws applicable to their contract. Now, while that may seem surprising and perhaps illogical to a judicial eye, those are nevertheless the express choices made by the parties, and we say which must be given effect to as they were by the arbitral tribunal in its award. Now, having regard briefly to the amalgamation of express choices made by the parties in this case, the arbitral tribunal found unanimously that French law applied to the arbitration agreement, and that is clear from the award of paragraphs 124 and 127, but also the dissenting opinion at paragraph 70, and those documents are in the appeal bundle at pages 439 to 440, and also at page 541 respectively. Now, while on an Article 51A challenge, we say that the court is, of course, not bound by the arbitrator's decision, it's noteworthy, however, that such finding was unanimous. And also noteworthy, we say, is the fact that while he had agreed with his fellow arbitrators that French law was the law applicable to the arbitration agreement, the dissenting arbitrator did not then go on to apply French law to the questions of jurisdiction, e.g., whether the respondent herein was bound by that arbitration agreement. The majority tribunal did go on, and they went on, one, to apply French law principles and find that there was a valid arbitration agreement, two, to grapple with the twin applicable laws of English law and unidroit, which they applied to the substance of the case at paragraphs 203 to 206 of the award, which are at bundle pages 461 to 463. Now, while this court is not bound by the arbitrator's findings, the appellant respectfully submits that the majority tribunal correctly proceeded to follow the letter and spirit of the FDA by applying the laws which the contract expressly required them to in order to arrive at their decision on the merits, which of course does not and cannot fall within the ambit of consideration of any New York Convention challenge before this court. We also say that it is a somewhat noteworthy irony in this case, which now comes before the UK Supreme Court, that the express language of the contract written in 2001 and agreed nearly 20 years ago to the day is clear and demonstrates that the parties did not want to choose England as the seat of arbitration, nor did they choose the English courts as the forum within which to resolve their disputes. That's evident from the fact that they chose to arbitrate any disputes in Paris, France. They didn't choose to arbitrate in London. Now, at the time of contracting in 2001, we say that it is unlikely that the prospect of there ever being any proceedings in England was within the contemplation of the parties at all. They even chose to insert specific language in the FDA at Article 14.7, which is page 379 in your bundles. The award of the arbitrators shall be final and binding upon the parties and shall be automatically enforced without any revision of the merits of the case by any court of competent jurisdiction. Of course, that betrays perhaps a lack of understanding on the part of the parties signing this contract of the way in which automatic enforcement cannot take place without the assistance of the New York Convention, which we are discussing in this case. Now, we say that that clause 14.7 in the FTA was an attempt to provide belt and braces finality to the parties' selected dispute resolution mechanism of arbitration, and notwithstanding the finality of the award and the binding nature of the ICC arbitration process envisaged by the ICC rules. And so, given their choice of Paris as a seat for their arbitration and the 14.7 attempted finality clause, we submit that it's commensurately unlikely that the parties ever intended that English law be the law applicable to their ICC arbitration agreement. That's especially so, we say, having regard to the fact that both these international parties were likely not terribly familiar or comfortable with English law, to the extent that they personally knew or understood it at all. And we say the demonstration of that fact is writ large in the express language of the contract, where the parties decided to include an express good faith and fair dealing provision as the very second clause. FTA Article 2 is at bundle page 371, my lords. And that provision, we say, may reasonably be inferred to have been intended to provide some protection to the franchisor, Kabab-Ji, the appellant here, a Lebanese company, whose brand and whose products were being franchised out for use in the territory of Kuwait to Al-Hamazi Foodstuff Company, a part of the Al-Hamazi Group, which already included the respondent company. For Kout Food Group, KFG, the respondent to this appeal, under its former name Gulf and World Restaurants and Foods Co., was incorporated in 1998, some 3 years prior to the signature of the FTA, as demonstrated by its Articles of Association, and those are at page 571 in the bundle, and as mentioned also in KFG's annual report of 2014, and they are at page 814 in the bundle. Those facts are also demonstrated by the front page and recitals to the FTA at page 370, and we say those are instructive as to the commercial background and purpose of the FTA. The parties also chose to invoke and mandate the arbitrators to apply the unidroit principles by virtue of FTA Article 14.3, and I will be taking you to that language shortly. It's at bundle page 378. Finally, we say it's noteworthy also that the appellant hails from Lebanon, which has laws based directly upon French law. The respondent and its affiliate AHFC, which signed the FTA, hails from Kuwait, another principally civil law jurisdiction, which has inherited the greater part of its laws indirectly from France via Egypt, but which has also inherited a part of its laws from England. We say that the parties, of course, must be taken to have known when designating Paris as the seat for their arbitration, that in accordance with French law as the lex fori, the validity and existence of the arbitration agreement, if challenged, would be determined not by reference to the law of the main contract or any national law, but by reference to the intention of the parties, taking into account acts of contractual performance according to French substantive rules of international arbitration. This was done by the Paris Seat Arbitral Tribunal and has ultimately and finally been decided by the Court of the Seat on the respondent's application to annul. And that's the decision of the Paris Court of Appeal of 23rd of June 2020, which is in the bundle at pages 551 to 570 in original and then translation thereafter. Now, as my Lord Sales noted as 277F in this court's decision in Enker, that's bundle page 1807, the parties are presumed to know the state of the law at the time they contract. Also in Enker, this is at bundle page 1762 and paragraphs 142, my Lords Hamblin and Leggers, in a section of their judgment entitled Giving Effect to Commercial Purpose, found as follows. The third reason for applying the law of the seat as a default law is that it's likely to uphold the reasonable expectations of contracting parties who've chosen to settle their disputes by arbitration in a specified place but made no choice of law for their contract. This is particularly so, whereas is often the case in contracts made between parties of different nationalities, popular seat of international arbitration has been chosen as a neutral forum with which neither party is connected. In such circumstances, if the parties had been required to make a common choice of law to govern their arbitration agreement at the time of contracting, it is inherently unlikely that they would have agreed on either of their national systems of law, and much more likely that they would have settled on the law of the place which they'd chosen as the seat of arbitration. Now, in order, the difference in this case with the example stated above by the majority of this court in Enker at paragraph 142 is as follows. Here, of course, there was no absence of any choice of law to govern the main contract, but rather the parties expressly chose and settled upon agreeing an equivocal addition or amalgamation of applicable laws, one national English law and one a set of international legal principles, namely unidroit. As we stated at paragraph 8 in our written case, and that's at bundle page 154, under English law, this leads to an effective no express choice of law applicable to the arbitration agreement, because per Russell at paragraph 2119, and that's page 1954 of the bundle, English law requires an arbitration agreement to be governed by a national law. In addition, and as I've already mentioned, the parties chose to contract for arbitration as a final dispute resolution mechanism for any disputes not susceptible to review on the merits by any court, they wrote, and they specifically stated the same at Article 14.7, which I've taken your lordships to at page 379 of the bundle. They chose to seek their arbitration in Paris in a detailed arbitration agreement containing some 7 sub-clauses. I will now proceed, my lords, to our submissions concerning the meaning of the precise and express language of the FTA and its commercial purpose, and then I will turn to the principles of law which the appellant submits this court should apply in order to determine what the law applicable to the FTA arbitration agreement is. My lord, 2 questions arise here, which I will address in turn, taking the facts first before I turn to the law and then seek to apply the law to the relevant facts. The first question is, what does the specific language of the relevant contract tell us about the intentions of the parties? The second question is, should this court give effect to the parties' commercial purpose as stated in the express contractual language? We say that the commercial reality here is that the parties did expressly choose to amalgamate and multiply the laws applicable to their contract by specifying the application of both English law and also unidroit, and then further also by selecting ICC arbitration with a Paris seat. The factual background to this is stated in our written case at paragraphs 18 to 25, that's bundle pages 156 to 157, and 55, bundle page 166, but also in extenso at section B of our written case at paragraph 63 to 89. Those are in the bundle at pages 168 to 174. I've said that the parties to the FTA were non-English international parties, and the commercial purpose of the FTA was to franchise out the appellant's restaurant brand and products and license operation of Kabab-Ji restaurants within the territory of Kuwait. Now, as I mentioned earlier, this express amalgamation of laws was likely the result of a compromise during the party negotiations, and again brings to mind the guidance given by my Lord Hodge at paragraph 11 in Wood and Capita, bundle page 1676, to the effect the court must not lose sight of the possibility that a provision may be a negotiated compromise, or that the negotiators were not able to agree more precise terms. Here we say that the express language chosen by the parties to specify the application of each of unidroit at articles 2 of the FTA and 14.3, and then English law at article 15, was what made business common sense to these parties in order for them to reach agreement. There are no provisions in language or within the express language of the FTA which provide for hierarchy. We have two provisions, Article 14.3, second sentence, which I shall come to in a moment, but I shall take Article 15 first in terms of its language. There are two provisions. Article 15, at page 378 of the bundle, says this agreement shall be governed by and construed in accordance with the laws of England. But then Article 14.3, which preceded in order Article 15, says at its first sentence at page 378 of the bundle, the arbitrators shall apply the provisions, that's in the plural, contained in the agreement. We say that that means all provisions contained within the agreement are to be applied by the arbitrators, and we say that that is without favour or preference, because there's no language of preference or of hierarchy in the contract. Article 14.3, second sentence, on the same page of the appeal bundle, then states this: the arbitrators shall also apply principles of law generally recognised in international transactions. Now, we submit, my lords, that where the parties have made such a clear and express choice to amalgamate the laws applicable to their contract, as was the case with the Channel Group applicable law clause, then effect must be given to that express choice, even if from a legal or judicial perspective, it may seem to have been an illogical choice for the parties to have made, because they didn't choose one law only to apply to their whole contractual relationship. We say that, as Wood and Capter demonstrates, the question of text and context, the linguistic reality and commercial purpose of the FTA and, of course, the FOAs, must be the paramount consideration in divining whether the parties here made any express choice concerning the law applicable to the arbitration agreement. So I shall now, my Lord Legate.
So we're not the arbitrators deciding what law to apply to the substantive dispute. We're a court deciding whether to enforce the award. And for that, we have to decide what law governs the arbitration agreement. At 14.3 doesn't tell us that, does it? Clause 15 does.
My Lord, we say that Article 15 does not say clearly, because of the context and the text of Article 14, Article 1, which I'm going to discuss and look at the language of now, Article 2, and in particular within Article 14, Article 14.3 in its entirety, all four sentences of it, but the first, second, and fourth sentence are the most important, and then also potentially Article 14.4, second sentence. Might I go straight to the language, my Lord, in respect of Article 1, 2, and then Articles 14 and 15, because then what we say, whether my Lord accepts this or not, will be perhaps clearer.
Right.
Article 1, my Lords, of the FTA is at bundle page 371. The language of this clause simply says that the agreement shall be construed as a whole. But we say that that does mean, of course, that one must construe the FTA as a whole. And of course, that is the English law rule of construction, which I will come on to, having examined first, as I now do, the language of the FTA. So on a true construction of the agreement, the parties intended purpose, we say, it is not possible to cherry pick which clauses to read or take into account, and one has to look at the whole of the language of the contract. My Lord Legate.
Do you accept that clause 14 is one of the terms of the agreement, and that when you read Article 1 with Article 15, it therefore is expressly telling you that all the terms of the agreement, including the arbitration clause, are governed by English law?
My lord, that's reading Article 1 in conjunction with Article 15 only, as opposed to reading Article 1 in conjunction with Article 2 or Article 14.3 second sentence. And our point is there's a circularity in the language. Because there's no express language in respect of the hierarchy or order of precedence of the clauses, we say that there is circularity in the language. All clauses are equivalent in the sense of having equal value, and that when that instruction is given at Article 14.3 first sentence, which reads, my lord, the arbitrators shall apply the provisions contained in this agreement, that means all of the provisions, as I've said, without favour or preference. And so we say that there is an equivalence in respect of the provisions. The parties clearly chose directly after specifying, and I'm coming on to, my lord, the language of Article 2 very shortly. So does that assist you, my lord?
Well, no is the answer. Not really, but there may not be much more you can say. I mean, do you accept that the agreement in clause 15 is a term which includes the arbitration clause?
My lord, it certainly does, by its language, include the provision at Article 14, because it refers to this agreement, and this agreement is the whole agreement, and therefore all of the clauses of the agreement. But as I've said, the clauses demonstrate that the parties expressly chose to give effect to not only English law in application to their contract, and to consider, as arbitrators did, as the Paris Court of Appeal has, and as now this court does, to consider what the applicable laws or answer to any dispute arising under the agreement might be.
Thank you.
My lords, Article 1, as I've said, because it instructs that the contract is to be read as a whole, means that one can't cherry pick which clauses to read and take into account, or which clauses to read together. And that's why we say that one can't simply read Article 1 and Article 15 together without considering Article 14, or indeed all the other provisions of the contract, which happen to include also Article 2. We've noted the fact that there's no hierarchical language, either within Article 1 or other articles of the contract, or the clauses. It's a standard form of clause, we say, to state what documents agreement and should be read as forming part of it. And we say it's nothing more than that and nothing less equally. Article 2 of the contract, also at bundle page 371, my lords, is the very first contractual provision within the FTA, which sets out rules of law which apply and are effective to govern the parties' interaction under the FTA. It says, in carrying out their obligations under this agreement, the parties shall act in accordance with good faith and fair dealing. The provisions of the agreement, as well as any statements made by the parties in connection therewith, shall be interpreted in good faith. Now, my lords, the language of Article 2 is very specific, prescribing not only an obligation of good faith, but also one of fair dealing. And in doing so, Article 2 echoes the precise language of UNIDROIT concerning good faith and fair dealing. And to that effect, I'm referring to UNIDROIT Principle 1.7, that's at bundle page 1405. Article 1.7 of UNIDROIT, which is entitled Good Faith and Fair Dealing, states, 1. Each party must act in accordance with good faith and fair dealing in international trade. 2. The parties may not exclude or limit this duty. Now, we say, of course, moreover, Article 2 FTA contains a good faith interpretation provision, to which I shall return later in my submissions concerning issue 2 and issue 2. But a core feature, we say, of this duty of good faith and fair dealing is the obligation to act consistently. Now, directly after that provision, at 1.7 in the UNIDROIT principles, follows another provision in UNIDROIT, which is Article 1.8, and that's over the page at bundle 1409. Article 1.8, entitled Inconsistent Behaviour, states, a party cannot act inconsistently with an understanding it has caused the other party to have, and upon which that other party reasonably has acted in reliance to its detriment. Again, Article 1.8 will be relevant to submissions further down the road in relation to issue 2, my lords. I now proceed to Article 14.3 and the language of FDA Article 14.3.
Before you go to
Now,
14.3,
yes, my lord.
Article 2 of the FDA, which imposes the obligations of good faith and fair dealing, of itself doesn't indicate the application of any particular system of law. It is a provision which you could include in an English law contract on any occasion you chose to do so, is it not?
My lord, absolutely. But it does use language which is noteworthy, we say, which is very similar to the language of UNIDROIT, and of course we'll come on to 14.3 second sentence and the fact that the Court of Appeal found, and that is now raised judicata, it wasn't appealed by the appellant, it wasn't cross appealed, that the second sentence of 14.3 did mean the UNIDROIT principles.
Yes, but of itself, Article 2 is neutral as to the governing law. But you are saying that if you read it with 14.3 second sentence, it has a more significant meaning. Is that the position?
That's correct, my lord, because one has to try and strive for coherence. At least there is some consistency and coherence textually and contextually as between these different provisions in the contract, which are to be read, as we've seen, at Article 1 as a whole. But of course, English law also instructs us, as the law of the forum now, to read the contract as a whole. And so one is looking at what the full commercial reality and purpose and intention of the parties was to this contract. And what I say is that there clearly must have been some tension in negotiations in respect of the contract, because, of course, notwithstanding the potential validity of conflict of laws theories of dépassage, etc., we understand that this court has said clearly in Enker that it is reasonably to be expected that parties want to achieve coherence across their contract. Now, that certainly may be the case of parties who are English parties or who are well informed as to the state of English law. It may or may not have been that these parties had substantial involvement from lawyers, but whether they were English lawyers or not is not something that we know in respect to this contract. What we do know is that the commercial bargain which they struck and which they eventually reduced to writing includes two things, which are certainly, well, three things, my lords, which are not English law at the time of writing, and I'll come on to that point later, if I may. The first is,
except I mean, Article 2, you can't say it is not English law. It may not be a building block of English contract law, but parties quite often in English law contract put in good faith clauses. There's nothing unusual in doing that in what is unquestionably an English law contract.
my lord, I accept that entirely.
Yes.
That's not the point I'm seeking. I'm not trying to make a point to say that it's a particularly unusual thing, because where, for example, there might be licensing out of a brand and intellectual property associated to it, it's perfectly conventional that a party who's franchising it out might want to ensure that there is good faith and fair dealing in respect of the use of the brand and the product which it has developed, or the intellectual property it's developed. So I entirely accept that, my lord. But what I do say is relatively striking is the consonance of the language at Article 2, this duty of good faith and fair dealing. It's not uncommon to see a duty of good faith written into an English law contract, whether or not that be now necessary, because of course the state of the common law has developed since the time when these parties signed their contract in 2001, and that thanks to, of course, two notable decisions of my Lord Legate in the Am Seng and also in the Al Nyan and Kent case. And that in relation to relational contracts, which I shall come back to a little later, if I may. But my Lord, what we say is that there is a clear echo of the principles of unidroit, which are specifically invoked in the language of 14.3 second sentence, because it is less usual, we say, for the parties to stipulate. My Lord Legate has a question.
I could see, Mr. Chair, that this might assist you in developing an argument that it's not purely English law that you apply in deciding whether the contract is valid, but there's some, or the arbitration agreement is valid, but there's some additional principles. But I don't see at the moment how it gets you anywhere near saying that they haven't chosen any law, which I thought was your opening submission, or that they've chosen French law. I mean, this doesn't even approach either of those points. All it shows is there might be a bit more to be added to English law that you must take into account. In terms of unidroit, that seems to be the high point of it so far. How are you possibly going to get to no choice of law or French law as a serious argument?
My Lord, I shall proceed and hope to convince you as I build upon the language of Article 2, now moving into Article 14.3.
Well, we will allow you to develop your argument.
Yeah.
I beg your pardon. Should I proceed, my Lord?
Yeah. Please do. Sorry, unless Lord Legate's wishing to.
No.
No, take us on to Article 14.3. Thank you.
Yes, my Lord. My Lord, in its written case on the law applicable to the arbitration agreement, we say that the respondent rather seems to ignore the party's specific contractual application of the unidroit principles in addition to English law by virtue of Article 2 and also Article 14.3 FTA. And those are at bundle pages 371 and 378. But we say it cannot do so. In this case, the Court of Appeal found correctly at paragraph 64 of their judgment, and that's at bundle page 283, that the second sentence of Article 14.3 indicates the unidroit principles. What Lord Justice Flo said there was that the arbitrators are directed to apply principles of law generally recognized in international transactions, in other words, for present purposes, unidroit principles, in addition to applying all the provisions of the agreement, including the governing law clause. As I've mentioned in response to my Lord Hodge, that finding has not been appealed or cross-appealed, and so it is res judicata. Now, the second sentence of Article 14.3 FDA uses more specific language. It mandates the arbitrators to also, and I place reliance upon the word also, apply the unidroit principles. In the appellant submission, that choice was an express and interesting and noteworthy choice because it demonstrates 5 things, we say. First of all, that the contracting parties could not reach agreement that English law only would govern their contractual arrangements. And there I note again, of course, they didn't choose to arbitrate in London. Secondly, they also agreed both English law and also the unidroit principles, which have at their core the principle of good faith and fair dealing, which is mentioned at Article 2. Now, thirdly, the parties chose to invoke at Article 14.3 second sentence and to apply, and I ask your Lordship to take note of the word apply, which I shall come to consider in relation to Article 15 and the word govern. presently. So they chose to invoke and apply the unidroit principles, and that's a choice which is consonant with another important clause which the parties chose to insert in their contract, namely Article 2, which I've already mentioned. Now, fourthly, we say that the insertion of a specific good faith and fair dealing clause strongly suggests that the parties, when they contracted in 2001, may have been aware that English law alone would not imply or mandate by operation of law any duty of good faith and fair dealing into a relational contract such as the FDA. And indeed, of course, we place reliance on my Lord Sales at paragraph 277 in ENCA, which I've already referred to. The parties are presumed to know the state of the law when they contract. Of course, I must pause and in parenthesis mention that, of course, the English law position has now evolved and changed as a result of the decisions of my Lord Legate in Yamseng at paragraphs 131, 142 and 145, bundle pages 1662, 1665 and 1666. And also later in the L9 Kent case at paragraphs 167 to 176, and that's at appeal bundle pages 2448 to 2451. And it's noteworthy, of course, that in between those cases, the Court of Appeal in Globe Motors in 2016, at paragraph 67, that's bundle page 2360, had cited the Yamseng decision with approval. We say it's also noteworthy that in his written case, at paragraphs 93 to 96, and that's bundle pages 236 to 237, the respondent does not dispute that the FDA was a relational contract. The fifth and final point in this respect is that in choosing to mandate the arbitrators to apply the unidroit principles, the parties opted for the application of principles which are perhaps more flexible and less formalistic than English law in at least three important respects. First, we say the unidroit principles place emphasis on actual and factual contractual performance by a party as denoting an intention to be bound. Secondly, we say that the unidroit principles expect that parties may behave inconsistently, and they provide sanction for such behaviour because it is at odds with the principle 1.7 under unidroit of good faith and fair dealing, which is at page 1405 of the bundle. My lords, the sanction for inconsistent behaviour under unidroit is preclusion, and a party may be precluded from asserting it's not a party to a contract if such assertion is inconsistent with its behaviour, and while that behaviour must be by words or conduct, we say, and I shall return to this point in relation to issue 2, that the words or conduct need not be unequivocal, and that's pursuant to unidroit principles 1.8 and 2.1.18, which are at bundle pages 1409 and 1418. My lords, I now come on to Article 14.3.
Would that be a point for us to adjourn for the short adjournment and resume again at 2 o'clock?
Grateful, my lord.
Yes, the court will now adjourn. Thank you.